Welcome, everyone. I am delighted to be here today to talk to you all about powers of attorney, a fascinating topic, using powers across borders. And today we're going to focus specifically on incapacity planning between Scotland and France, though I know Xaviera is going to bring in some examples from further afield as well on certain points. And we thought that this was really important because the world's population is aging. Significant advances in medicine and healthcare mean that we're all living much longer, and with that comes in particular an increased risk of neurological disease, and the most common being dementia. The risk of developing dementia increases exponentially with your age. And in a recent report published this month by the Scottish Mental Welfare Commission, we recorded 4,300 new guardianship orders granted in the year 24-25, and 32% of those related to dementia diagnoses. And at the same time as all of that, the world's becoming a much smaller place with an aging and more globally mobile population. The need for that comprehensive regime that provides that support, that safeguards, and that enables vulnerable adults and those with incapacity has never been more important. And it's against that backdrop that we thought that this would be an interesting thing to talk about in an international context. So, before we get into the detail, I just wanted to introduce myself. I'm a partner here at Brodies in our personal team. My name is Jessica, and I'm also a committee member of the Scottish section of the Franco-British Lawyers Society that has very generously co-hosted this event. I am a Scottish solicitor, but as many people in the room know, I have a particular passion for cross-border work involving France, and I regularly work with advisors like Xaviera, who's come all the way from Paris today to help clients with interests in those jurisdictions. I'm really delighted that some people from Brodies have come along to see this today, and also that we've got some representation from the Franco-British lawyers. So Carol, thank you very much for coming along. There are also many FBLS members who are joining us remotely. This is our first hybrid event, or certainly my first hybrid event. And I'm delighted that we have people joining from the Franco-British lawyers, both in Scotland and in France, online. I wanted to thank our BD team, Rachel and Robin. Thank you for putting this together, as well as the FBLS. Thank you for helping to organise this and for helping to put it together. And I'm really delighted to welcome Xaviera, who is joining us today from Paris. Xaviera is a partner at Notaires in Paris, and she's head of the private international law department there. She is very talented. She's fluent in English, and she specialises in family law, succession, property, and incapacity. And we're so pleased to have you joining us today, Xaviera. So it's really a pleasure. You've been so gracious to me every time I've come to Paris. It's really nice to be able to return the favour and to host you here in Edinburgh. So many of us are familiar with the measures that are available in Scotland to protect vulnerable adults, but Xaviera is going to discuss what options that there are in France and how adults with interests in multiple jurisdictions, notably in Scotland and in France, should prepare for incapacity. But before she does that, I wanted Xaviera just to give us a very brief introduction to the role of notaires in France, because we don't have the same distinction in the UK between a solicitor and a notaire. And in France, as in other civil law jurisdictions, lawyers and notaires are two completely different things. And it's important for us when we're advising clients with connections to France and those civil law jurisdictions that we understand that, particularly in the context of incapacity planning. So Xaviera, I will pass over to you so that you can talk to us about that.
Thank you. First of all, thank you very much, Jessica, for inviting me. It's a pleasure to be with you here in Edinburgh. So just to sum up, what is a notaire in France? A notaire in France is a public officer, is appointed by the Minister of Justice, and we have a part of its public authority. Even if we are a public officer, we have to keep in mind that we have our own notarial firm and we work as independent. We deliver a service of authenticity. And all the notarial deeds we are doing are highest level of authenticity. It means that it's very difficult to challenge. And that's why under French law, only notaries are authorized to do a certain numbers of acts, and nobody else can do it. You need to understand that the everyday life of a notary in France is to settle succession, to do real estate sale, and to do everything related to matrimonial property regime matters. Prenuptial agreement, change of matrimonial property regime, that's our main activities, and we are the only one authorized to do that. And anything linked to a transfer of an immovable asset must be done through a French notarial deed, because we are the only one authorized to do the deed and publish the deed to the French land registry called Service de la Publicité Foncière. And in addition, we are doing authentic deed. Some provision of some articles of the French Civil Code provide that certain types of acts must be done through a notarial deed, such as authentic will, such as a prenuptial agreement, change of matrimonial property regime, and also some kind of gift called donation partage. Today, I will try to sum up to explain the system for vulnerable adults in France. And I have divided the presentation, my part of the presentation, in two parts: the judicial measures and the non-judicial measures. Under French law, there is different levels of protection that can be ordered by a French judge, and it depends on the level of incapacity of the adult with incapacity. The first level is what we call, I will say it in French, curatelle simple. It's when it's a light alteration of the capacity of the adult, and the adult has still a certain autonomy. It means that for their everyday life, the adult will continue to do certain things, such as paying invoices, doing some managing his checking account. But for more important acts, such as selling an immovable asset, he will need an assistance, and he will need to be assisted of what we call his curator. And we must know that in that case, we will have two signings: the signing of the adult with incapacity and the signing of the curator. Each time I have mentioned the articles of the French Civil Code where it is mentioned for you to refer if needed. After, you have what we call the curatelle renforcée for adults with more severe incapacity. It means that the curator will assist the vulnerable adult even for the everyday life, for managing the checking account, for paying the invoice, doing the income tax returns every year, these kind of things. And after, the highest level of protection for a judicial measure that a French judge can order is what we call tutelle, which is the most common. It's when an adult can no more act on his own because he has lost permanently his capacity, such as Alzheimer's disease or brain injury. And in that case, that's the main difference with the curatelle. It won't be assisted by the guardian. It's the guardian called the tutor, who will act on his behalf each time, and there won't be the signature of the vulnerable adult. So the the tutor will act on his behalf for all the matter, everyday life, and for very significant acts such as the sale of an immovable asset, main residence or an apartment who is renting, to withdraw cash from life insurance, because as you might know, the French people, they love life insurance and their savings are always on life insurance. They will require to apply, to make an application to the judge in order to obtain an authorization. In this kind of, yes?
So just to ask, Xaviera, so the difference between curatelle and tutelle, curatelle is, from what I understand, a means of protection whereby an adult is assisted by somebody else, but their authority isn't completely delegated, whereas under a tutelle, someone's acting on behalf of somebody else.
Exactly, that's the main difference. In both situations, we consider that they have lost their capacity. So they are considered as adult with incapacity. I insist on that point because we will see a difference with the non-judicial measure. But in both situations, they have lost their capacity, but we continue to give them some powers to do certain things under curatelle, while it cannot do anything under tutelle.
Mm-hmm. And the process for getting that additional authority from the court, from the judge, would that always involve a hearing? Would you have to actually physically go to court?
No, it depends. It depends. As I will explain, this judicial measures is quite a heavy and complex procedure because it takes a lot of time. And indeed, each time we need an authorization of the judge, we must make an application, send documents. Sometimes when the situation is complex, the judge will ask for the hearing of the guardian of the family. It can happen when it's a complex notarial act which is submitted, the project, for like complex donation to different generation of descendants. Sometimes the judge can even ask to hear the notary. It happens to me once because the judge wanted to understand very clearly the tax consequences of the project of the notarial deed and things like that. So the main problem of the judicial measures is that depending on the areas of France, to obtain just the tutelle or the curatelle, it can take 2 months, 3 months if you are lucky. And if you are not lucky, if it's an area of France where there is not a lot of judges, it can take 8 months, 10 months, sometimes 1 year. And the same delay just to obtain an authorization, for example, just to sell the main residence because the vulnerable adult needs to be in a nursing home, and it costs a lot, and you need to sell the main residence, and you need to obtain the authorization of the judge of the relevant court, and it could take 6, 7, 8 months while there is no funds to pay the I have just on the document explained the process to obtain the order from the judge. So first of all, it will be a medical report from not a regular doctor, but a doctor appointed by the Court of Appeal. And then you have to make an application, as explained, and to give a lot of documentation to obtain the tutelle or the curatelle.
And you need to do that for curatelle as well?
Yes, exactly. Each time it will be a medical report and the same application. And then the judge will decide the level of the measure he will order, curatelle or tutelle, depending of the incapacity of the adult. And once the judgment is delivered, the guardian will obtain the powers. He will act on behalf, curatelle or tutelle. And what is important is that in France, on the birth certificate of all French citizens, all the life of the person is on the margin. If you are married, if you are divorced, if you are linked by a civil partnership, if you have changed of family name, and if a tutel or curatelle is ordered, then there will be on the margin a mention called RC for répertoire civil, and then a notary, for example, or a judge or a policeman who will consult the birth certificate will see this reference on the margin, and then we'll see that the person, he will look at this register and see if it is a tutel or curatelle, and then how he can organize the signing of the deed of donation or deed of sale, for example. I have just mentioned the list of the person who can be appointed for a tutel or a curatelle, the guardian. So as you can see, most of the time is the close family, but sometimes in conflictual situation or when the vulnerable adult is isolated, it's quite common that it is a judicial representative who is appointed, and it can be either a natural person because it is his job, or most common an institution like UDAF. There is one UDAF in each department, and it's a kind of, we say association in French, but it's like an institution. It's not the government, but it's an institution, and they are appointed to be the tutor or curator of lots of vulnerable adults. And what the guardian's obligation, and another problem of these judicial measures is that every year the guardian will need to produce annual account, managing report, doing updated appraisal of the assets and liabilities of the vulnerable adult. And he will have to produce all these documents once a year to the relevant judge to prove that he's acting correctly, he's doing his job regularly. So that's why the judge specialized in vulnerable adults are under 1,000 and 1,000 of files, and it's very complicated and long to obtain order because they have to check to deliver a lot of orders for just withdraw cash from life insurance, and to check all that annual accounts. It's a big job.
So I just want to compare the position in Scotland with the French position. I'm just going to follow Xaviera's lead and talk about some judicial measures, not all of them, but just some at a high level. And a lot of people in the room are going to be very familiar with this piece of legislation, which actually was the first enacted by the Scottish Parliament, but for the benefit of those. The Incapacity Act provides the framework in Scotland for the protection of property, finances, and welfare of adults. And in Scotland, that means people that are aged over 16, adults who are incapable. Interestingly, there's no definition of capacity in the Act. Instead, an adult will be incapable if they're incapable of acting, making decisions, communicating decisions, understanding decisions, or retaining the memory of those decisions. And that definition of what it means to be incapable is caveated in the sense that a lack of ability to communicate alone that can be made good by either human or mechanical aid does not mean that an adult is incapable. There are various measures available to protect adults under the Act. Whatever that measure, a person that is authorised to take decisions on behalf of an adult must act in line with the general principles set out in the legislation. The intervention, whatever it is, must be for the benefit of the adults. It should always be the least restrictive option available. The person that's authorised to act must always take into consideration the views of the adult insofar as it's possible to obtain them, as well as views of other people who've got an interest in the adult's property and welfare. and the adults should also be always encouraged to exercise whatever skills they can do, as well as to develop new skills. There are a number of bodies in Scotland that have a role, and in Scotland, the sort of bodies with the greatest role in supervising guardians are not the court, not the judge, but a number of bodies that are responsible for supervising and advising those who have authority to act on behalf of incapable adults. And the sort of three main ones are the Office of the Public Guardian in Scotland, the Mental Welfare Commission of Scotland, and also relevant local authorities have a really significant role in supervising those acting on behalf of incapable adults. So as I've already mentioned, there's lots of measures available under the Act, lots of judicial measures available under the Act, but I wanted to, as a means of sort of comparing and contrasting the French curatelle and tutelle, talk in particular about guardianship, which is one of the most common. There are two forms of guardianship under the Act. I want to talk about welfare guardianship first. So if an adult is incapable of making decisions regarding their personal health, well-being, then on application by a person with an interest in the adult's welfare, a sheriff in the relevant sheriff court of the area in which the adult resides can appoint a welfare guardian to make decisions on the adult's behalf. Unlike in how Xaviera has described that an organisation can be appointed to act on behalf of an incapable adult, that is not the case in Scotland, which is a huge difference. So no organisation or institution or body can take on that role. It must be an individual person who is appointed. Where there is no one who is applying to be appointed as a welfare guardian, and an adult is in trouble or is having difficulty safeguarding their own welfare interests, then the local authority in the relevant area in which the adult resides must make an application to have a welfare guardian appointed, and the chief social worker of that local authority can be appointed, but that is an individual person who would take on that role. The welfare guardians are under the supervision of the local authority, and the local authority will also provide that sort of advisory role as well for people who are appointed as welfare guardians. And what we talked about that Xaviera was where it's really common for a chief social worker to be appointed is in situations where there isn't anyone obvious or anyone able or willing to take on that role, but also in situations where there's conflict between different family members and there's no way of resolving that, then that will be a situation where it might be better to have a chief social worker appointed. So turning now to financial guardianship, again, is very similar to welfare guardianship in the sense that anyone who's got an interest in the adult's property or finances can make that application for that appointment. Again, the relevant local authority must apply if no one else is doing that, and it's essential to safeguard the adult's interests. It's where there isn't a person who can be appointed or is not a person who's willing to be appointed, then the chief social worker cannot take on that role. They can only be appointed in a welfare capacity, but it's quite common for professionals like solicitors to be appointed, and actually there are lots of solicitors that will be on panels for local authorities to take on that professional financial guardianship role if there's no one else willing to do it, or if the conflict in the family means that that's the safest and best option. Very much like under the French system of tutelle, financial guardians are subject to fairly significant levels of supervision. And as I said before, it's not the court that deals with that generally. it's the Office of the Public Guardian. So as a financial guardian, once a financial guardian is appointed, they must prepare an inventory of the adult's assets. They have to submit a management plan to the Office of the Public Guardian to set out how they propose to deal with the adult's estate. And then they're obligated, much like under tutelle and curatelle, to submit an annual account every year, which gets approved by the OPG. So it is a fairly significant supervision. Similarly as well, for those sort of quite serious acts, it's very important for the guardian to be given specific power in terms of the judgment in their favour. So the judgment that's delivered by the courts must outline what the guardian is able to do. But even if they have the power, for example, to sell real estate, they would have to get special permission from the Office of the Public Guardian to put a house on the market, for example.
Authorization.
Yeah, exactly. It's a second layer of authorization, and the Office of the Public Guardian will go through a process where they'll consult interested parties to make sure that there are no objections to that. And then even once you've got consent in principle, we call it, from the Office of the Public Guardian to, for example, market a house for sale, you would then have to submit your offer to the Office of the Public Guardian for them to say, yes, you can accept this offer. And the same would be said of gifts. You mentioned donation. The same would apply. You would need to get that special permission, even if you have the power to do it, and it would be essential to have the power to do it.
Donation in France would also require authorization from the judge, either in curatelle or either in tutelle. And just to finish on the comparison between Scotland and France, I just want to precise that a tuteur or curateur under French law has power, will cover the management of the assets, but although it's the person himself. It means that under French law, when a judge decides to appoint this person as a tutor or curator, it means that this person has power to decide on personal aspects on the life of the vulnerable adult. It means that, for example, even a judicial representative, when he's appointed as a tutor, will have the right to decide where the adult will live in this kind of nursing home, in this area or this area. So most of the time, in almost 99% of the cases, the tutor or the curator will have powers on both aspects, personal aspect and managing of the assets. That's an important point. So in the first part, I present the judicial measures, and then I wanted to make a focus on non-judicial measures, who are now more and more popular in France due to the long delay linked to the judicial measures. So the two non-judicial measures that I will present to you are what we see more and more in our work. The first non-judicial measure is very recent. It's called habilitation familiale, and it has been created in 2015. So you will say she's saying it's a non-judicial measure, but the first thing she's writing is that it's done by a decision of the judge. I'm not crazy. It's called non-judicial measure by all the law professors because even if it's done by judgment, after it's very light. There is no supervision almost. It is made for non-conflictual family. When aging parent has a start of dementia and a child or children want to ask to the judge to be appointed to act on his behalf. As you can see on the list, judicial representative, natural person or institution cannot be appointed through an habilitation familiale because it is made only for non-conflictual situation, just for family. I won't say normal family because there is a lot of conflict in all family, but for family without any conflict. And it aims to simplify the procedure to reduce, we must be honest, to reduce the number of files to the judge, because it was impossible not to have an order in some cases.
And it reduces the files going to the judge because they only have to see the judge once.
Yes,
right?
at the first time. So that's why the French judges, they love this new law. And they deliver a lot of habilitation familiale. Only when they see, each time they see a conflict, they go on the curatelle or tutelle. They never pronounce that in case of there is a conflict. And most of the time it's for habilitation générale. It means that one child or two child, it can appoint several persons, will represent the parent in his everyday life, and even for the most important acts such as doing action on the life insurance. And so in some cases, the judge can deliver only what we call habilitation spéciale, specific habilitation. The most common example is when a parent passes away and there is a surviving spouse and two children, and the surviving spouse has lost his capacity, and then the children, they just go to the court to ask just an habilitation specific in order to act on behalf of the surviving parent, in order to accept the estate on behalf of the surviving parent. So that the more common example.
Okay.
So this habilitation familiale is called non-judicial major because there won't be the annual account each year, and there is almost no order authorization to ask to the judge.
We don't have anything like that, so it's very interesting.
Yes,
to hear about that.
In that case, the vulnerable adult will be considered as having lost his capacity, and it will be from the French point of view as a vulnerable adult. Compared to the second non-judicial major, quite recent in France too, where I will explain, and it has been highly criticized in France, when the mandat protection future I will talk is open, the adult is still considered as having his capacity, while he has not. So the second non-judicial major is I call that the French durable power of attorney, which is very really like a very important change in our law, because until 2009, this kind of document of act didn't exist. While under common law, you knew durable lasting power of attorney since decades. Before 2009, it was impossible for an adult who has his capacity to decide while he still has his capacity, who will act on his behalf. It was completely impossible. And it is possible since 2009. It's the date where the Hague Convention for Adults, dated 2000, entered into force. And so there is two kinds of mandat protection future. One rarely used under private signature, so it's not a notarial deed, it's not an authentic deed, and it has limited effects. But which is very, very common in our notarial firms all over France, in every region of France, is to do authentic notarial deed. So there is not a week where we don't sign a notarial deed of mandat protection future, because parents, they are very, when they know that they can make a notarial deed to choose to say that the surviving, the other spouse or one of the child could be appointed as the guardian, we say mandataire in French, and to avoid the long delay of the judicial majors, such as tutelle, they always do that. So it's very famous in France now to do this.
The judges must like it.
Too, yes, too, because it's a real non-judicial measure because the judge will never see the family, except problem, of course. So once the notarial deed, let's say the notarial deed is signed today in 2025, 5 years later, one of the children, you see that the parent starts to lose his faculties. He will ask a medical report from a doctor appointed by the Court of Appeal, and he will produce the report to the clerk of the relevant court, and the clerk will write on the hard copy of the document that the mandat de protection future start to produce its effect on, let's say, 2030. And say in a few weeks, the mandataire will have the powers to act on behalf of the parents, in my example, and to do everything, such as managing the financial assets, paying the invoices, doing income tax return, selling any immovable assets except the main residence, which always very protected in the French law. So even in that case, it's an authorization from the French judge.
It's interesting that you need to take that action before
activating
the
mandat. It's quite quick. You obtain the medical report, you produce it to the clerk, or greffier clerk. And then it's okay. Because it's not
no, we don't need to do any of that. So our judicial measures, and we'll talk about the equivalent, the sort of Scottish continuing welfare power of attorneys. And it was interesting also to hear about the habitation familiale, because obviously there's no equivalent of that here. But what we want to do and how we want to sort of protect our clients is to really advise them to do this, because it's the simplest way of making sure that you don't need to that you don't need to go to court, and you don't need to bother with anything as sort of onerous as that. So mostly for the benefit of the people listening online, we have two types of powers of attorney in Scotland. And you can appoint a person to make decisions about your personal welfare on your behalf, and you can also appoint a person to make decisions about your property and your finances. You can appoint the same person to do both, or different people, and you can prepare both the continuing and welfare power of attorney in one document or in two separate deeds.
It can be
combined.
Yes, and in our mandat de protection future, it covers the person and the assets, always. And you can appoint one person to do both job, or one person for each.
Or for each job, Yes. So that's very similar. But unlike in France, there's nothing that we need to specifically do unless the deed is drafted in a certain way. But the sort of general default position is most common. You don't have to activate it necessarily. You can begin to use it if an adult has lost capacity in relation to welfare. But if an adult has not lost capacity, then you can use your financial powers while the adult is still capable. And then the reason that it is called a continuing power of attorney is because it continues to have effect after an adult has lost capacity. But that I think probably makes the kind of judicial cooperation elements between Scotland and other countries that are party to the Hague Convention, which we'll talk about just now, quite difficult, because we have that ability to use that document before an adult has lost capacity. And I know that in some other jurisdictions that's quite an alien concept. It's very unusual.
We have been I have in my notarial firm, we had that case. The adult has lost his capacity. We just had asked for a medical report to prove that he lost, to have our security that we can use the power of attorney, and that it was the son, in our case, appointed, that he could sign instead of his father.
So you would ask for that. So if you were presented with a Scottish power of attorney, even a continuing one that takes effect immediately on signature, you would ask for a medical report to confirm that the person has lost capacity. It's interesting. So in Scotland, the person signing the deeds, you must have capacity to prepare this document. And the person signing the deed has to be interviewed by either a solicitor, a Scottish solicitor, or a UK registered doctor immediately before they sign. And that certifier confirms that the person signing has got capacity to sign, isn't under any pressure to sign, and understands the import of what it is that they're doing. And we touched on this when we had a chat beforehand, because I know that France has come to criticism for not keeping a register of powers of attorney, but we have a register. So all these powers of attorney, before they can be used, have to be registered with the Office of the Public Guardian, and that is a publicly available register that is maintained by, as one of the sort of principal functions of the Office of the Public Guardian in Scotland. So you can check, that whether a document is registered.
Yeah, it's very useful because France has been highly criticized recently by European Union because we didn't, since 2009, there is no register created for mandat de protection future, activated or not activated. So recently we were forced, last year, we were forced to say we will create it, but we are still waiting for the official arrêté. We will say, yes, it's created. Because at the date of today, if I see a client, let's say, is a psychiatric and the mandat de protection future has been activated because he has a psychiatric disease, but some day is okay. If he comes to my firm, a day is good, he wants to sell, let's say, a parking space, I check his birth certificate. There is no mention in the margin. He looks okay. He's for 50 years old. I make it sign while the mandat de protection future is activated. So it's a big problem, and that's why Europe say you cannot continue like that, and they're right. But the register is not created yet.
Does the fact that the mandat de protection future is activated, does that mean once it's activated that the person that's granted it cannot act anymore? No. So that, I suppose that's a difference with us as well, is that the fact that a power of attorney is being used doesn't mean that the person who's granted it necessarily
when the mandat is activated, it doesn't mean that the person has lost his capacity, which is very weird. But let's say I would sign the deed of sale of a parking space. Someone could challenge and say he didn't have his capacity, so the notarial deed is null and void. So that's the main problem.
So we would, we have to be satisfied that a person has got capacity to take instructions, but the fact that a power of attorney is being used doesn't necessarily mean that. So it's interesting that the sort of activation of the document means that you sort of can't take instructions from the grantor. Is an interesting distinction, I think.
Jessica will speak about the convention, so she will speak about the convention better than me, but just a quick review regarding the applicable law for capacity from the French point of view. The general rule is provided in the French Civil Code, and Article 3 was still saying that a person's capacity is governed by his personal law. That's the general rule, because as mentioned here, it's now in the majority of the cases we apply the Hague Convention dated 2000, entered into force in France in 2009. Just a little point that can be interesting, no matter it's the French Civil Code rules that must be applied or the Hague Convention that must be applied, a foreign judgment in matters of capacity is always applied in France without any procedure of exequatur. It means that we recognize it and there is no additional procedure to do. So divorce, capacity, things like that, a divorce pronounced in US as it's linked to the personal situation of a person, we recognize it, no exequatur. Sometimes the rule of the French civil code continue to apply, for example, for a French adult who is a vulnerable adult and living abroad in a country where the Hague Convention does not apply. So there is some cases where we continue to apply Article 3, that's why I mention it, okay? But we make a focus on the Hague Convention. So dated 2000, that is applied in Scotland, but unless I am mistaken, not in England and Wales. So, you know, the Hague Convention, it helped to determine the applicable law for the capacity of the adult and also the relevant court. But what was really important from the French point of view, it is that Article 15 provides what we call generally mandate for incapacity. I could say that in English. And it was very new, really new for us. And at the same time, we create the mandat protection future, which is covered by the definition, of course, of Article 15. And thanks to these articles inside the Hague Convention, now every day, especially in Paris or in Nice or near Switzerland, where there is international situation, we apply very easily what we call durable power of attorney from foreign countries. For example, we usually apply US lasting power of attorney. Recently, I have the estate of a lady. She was married to a man. He was 95 years old with two children. They were all living in the US, but there are two immovable assets in France. So I have to settle the succession for the two immovable assets in France. And the surviving spouse were very old. He lost his faculties. And then he signed before a lasting power of attorney. And so I asked to the lawyer in charge in the US of the estate to make a legal opinion, explain me how this lasting power of attorney was signed, how it was working. And then I recognized the effect and I used the lasting power of attorney made in the US. And then the children were acting on behalf of the father to accept the succession in France and to receive and to be titled on the two immovable assets. So that's very common in France for notaries. I insist for notaries because we knew that rules and we have to apply. We must apply the Hague Convention. We really recognize foreign mandate.
The difficulty is when you're dealing with someone who's not a notary.
Yes. The only problem in international situation from our point of view is when I have a French client who wants to do a mandat protection future, and then several years after, he's living in a foreign country, and I took the example of Brazil to explain that even if it's a very good thing, the mandat protection future, very easy for everyday life, in some circumstances, we must say, no, don't do that. So it was the case of a client, a French citizen with all his family in France. And yes, he had significant assets in France. And at the end, quite significant assets in Brazil too. And in 2017, he decided to sign a mandat protection future because his family wanted him to sign because his life was a bit crazy in Brazil, so they want to make some secure stuff in France. And he signed the mandat protection future. And several years after, the family says, okay, the situation is not good now, and we want to activate it, to activate the mandat protection future. And in France, we have a very problematic, we say, réponse ministérielle, ministerial answer, dated 2018, who precise that when there is a mandat de protection future, signed by a French citizen, for example, but this person is living abroad, and if in the country the Hague Convention does not apply, we have to refer to the internal rules of the said country in order to activate the mandate. The thing is that in Brazil, there is no similar concept, and there is no similar mandate for incapacity, no durable power of attorney. So in that case, while the client was still living in Brazil, if he was still in Brazil, it was impossible to activate the mandat de protection future. So due to that difficult and inappropriate ministerial answer, in some circumstances, it's very complicated to make an advice to do that, because at the end, it won't be possible to activate it.
That's why more countries should ratify the convention. I'm just conscious of time, so I just wanted to touch on this briefly from the Scottish perspective. The Hague Convention, already introduced by Xaviera, but it's a piece of legislation that is aimed to address issues in protection of vulnerable adults across borders by coordinating those rules on jurisdiction and applicable law and recognition and enforcement of foreign measures in those states that have ratified it, and there are still few states that have ratified it. I'm very pleased that the UK did ratify the convention in respect of Scotland only in 2003, and Scotland was the very first state to ratify the Hague Convention. It is the Adults with Incapacity Act that implements the Hague Convention in Scotland, and it's Schedule 3 of that act that implements it. So essentially, under Schedule 3, any measure taken under the law of another country other than Scotland is recognised in Scotland, provided that the jurisdiction of the authority in the other country was based on the adult's habitual residence, or because the other country is a Hague Convention country, and because the grounds of jurisdiction were one of the grounds in the Hague Convention that I won't go into now, but they are set out in that schedule. There are very limited grounds for refusing to recognise a measure. It can only be refused in limited circumstances. One of those is that it's manifestly contrary to public policy, or that the adult hasn't been given an opportunity to be heard, and that constitutes a breach of natural justice. So assuming that none of those measures have been met, the grounds of refusal have been met, then the foreign measure is recognised in Scotland. There is a procedure to have that measure recognised. So in Scotland, you get a foreign measure recognised by summary application to the Sheriff Court, and then once that measure has been recognised, it is registered with the OPG, so the OPG maintains a register of all foreign measures, and it will then have the same effect as if it was granted in Scotland. So it's a very useful piece of legislation. When I'm talking about the measures under that Schedule 3, the term measure, I'm talking about judicial measures taken under the law of a country other than the law of Scotland. So there is a distinction where powers of attorney are concerned, and actually the law there is slightly less clear. So there is an argument that the reference to measure under Schedule 3 is a reference to a power of attorney, because it includes a measure that expressly it expressly includes the measure that appoints somebody or a body to have charge of a person's finances or property. But the more commonly held view, and the view of the public guardian, is that this Section 7 of Schedule 3 and reference to measures does not include powers of attorney. And it does not include powers of attorney because when read in conjunction with the Hague Convention, the references to measures taken rather than measures granted, and the view of the public guardian is that a power of attorney is granted, it's not taken. So it doesn't apply. There is another part of the Adults with Incapacity Act, Schedule 3 as well. There's another part of that that potentially provides us with a solution. This is Section 4 of Schedule 3, because it states that the exercise of a power of attorney is governed by the law of Scotland if that's the place where the power of attorney is being exercised. So that is a solution. Powers of attorney are automatically recognised in Scotland. So great, fantastic, we can use them. However, it's more complicated than that because there is no mechanism to enforce that power of attorney. There's no mechanism for getting it recognised and registered like a foreign measure could be registered. So you can't apply to the Sheriff Court to have it recognised, and then you can't have it registered on the foreign measures register with the OPG. So that means that if an organisation in Scotland isn't going to accept it, they should, but it means that if a bank, for example, if Bank of Scotland on the high street isn't going to accept your foreign power of attorney, there's no solution for the attorney appointed. They can't do anything about that. They can't enforce, they can't compel the bank to accept the terms of the documents. So it's not a particularly great sort of state of affairs. The public guardian is very cognizant of that and has produced a certificate which you can obtain on request by getting in touch with the public guardian, that you can basically append to your foreign power of attorney. If it was a French one, I suspect we would want it to be translated, but you can append that to your foreign power of attorney, and that states that it is automatically recognised and that the organisations in Scotland should accept it. But it's generally it's recognised that may or may not work. And this is where Xaviera and I are completely aligned. If I have clients with interests in both France and in Scotland, I will always advise them to prepare a power of attorney in both jurisdictions, because it will save a world of pain, and it just makes things so much easier to deal with. So that is the message. If you go with anything today, it's just do it. It's so much easier to do that. And finally,
try to appoint the same person in the same document.
Yeah, try to appoint the same person in the same document, but definitely do it because it just makes things so much easier. France knows a mandat de protection future. We know a power of attorney, and you will avoid problems. I just wanted to very finally, before we wrap up, touch on the fact that there is going to be, hopefully soon, reform of adults with incapacity legislation in Scotland. There was a consultation last year by the Scottish Government, and the proposals are to bring the law, which is now 25 years old, much more in line with sort of human rights developments, the UN Convention on the Rights of Persons with Disabilities, to make it a much more person-centred approach, and also to make it a bit less cumbersome, a bit easier. The Mental Welfare Commission actually published a report this month to sort of put a bit of pressure on the Scottish Government to accelerate the sort of timetable for reform. So watch this space. We hope that we see something soon, and maybe we'll have an equivalent to the habitation familiale in the future.
In fact, sometimes in non-conflictual family, we are at a point that when they come for a mandat de protection future, we say, now there is habilitation familiale, and it's easier than the mandat de protection future, because when the mandat de protection future is activated, once a year, the annual account must be produced to the notary who has draw up the notarial mandat protection future. So you still have a bit of reports to do when you don't have in habilitation familiale. So we're in very, very good family, we say sometimes it happens, rarely. Don't do that in case of you will ask for habilitation familiale.
Very interesting. So that's us.
Yes.
Yeah, thank you very much, everyone. Does anyone have any questions, either online or I'm going to have to use this now, or in person? Everything's obviously crystal clear.
Yes.
Jess, I've got a question.
Yeah, we've got a question. No, ask away.
There's a slight dig at England in there, and I just wondered, you recommend having power of attorney in Scotland and in France if you've got assets, or you got to live in both places. Is that the same for Scotland and England, or is it?
Yeah, I think our English colleagues would say yes, that you should have both if you have interests in both. The theory is the same. So the theory is that an English power of attorney or a lasting power of attorney would be automatically recognised here, and vice versa. But you are at the mercy of the organisations that you're dealing with, and if they don't, it would be the same situation if they don't. If the Bank of Scotland in the High Street doesn't recognise it, then you've got no means of forcing them to recognise it because it's automatically automatically enforced. So we do, and we do that a lot, for clients with assets or interests on both sides of the borders. We generally advise them to prepare both. I have, in a French context, done Scottish powers of attorney only, but I've working with a French notaire. I've kind of included clauses in the power of attorney itself that sort of refer to French law, to French assets, to try and basically, to try and ensure that it will be recognised. But we just have to explain to clients that unless you're going to see a notaire that knows the law and you're selling a house in France, and then that's almost easier because you have to do it through a notaire who understands the Hague Convention and understands that it's automatically recognised. But if you're going to HSBC Bank and they don't, then you might struggle. Yeah.
Type of question. Obviously, working with private clients, you try and promote creating a power of attorney as quickly as possible to not end up in a situation where you're having to go down the guardianship route, and the kind of trying to educate people. Is there the same problem there is in Scotland and France with the number of guardianships need to be active because people aren't doing powers of attorney in enough time? Is there kind of that knowledge of the importance of powers of attorneys being put in place?
Tu veux que je te traduise? Oui. Alors, elle demande si c'est difficile d'encourager les gens à faire un mandat de protection future, parce que alors la difficulté c'est si on fait pas, alors vous avez l'habilitation familiale, mais si on fait pas un mandat de protection future, c'est des fois c'est la tutelle, la curatelle, et c'est ça qui met la pression sur les juges, et est-ce que c'est difficile d'éduquer en fait la population, de les encourager à faire un mandat de protection future?
In fact, it's very easy to convince people to sign a mandat protection future, because generally French population is aware of the long delay of the French jurisdiction in those matters. So it's very easy. We really have no difficulty to convince people to establish a mandat protection future when, for example, there is a problem of one of their child, a family with 3 children, and one is always in the conflict while the 2 other have no problem. The parents want to avoid any problem if they lost their faculties, and they want to make the life easier for the 2 children that are in a good relation. So in that case, it's very easy. Sometimes it's also easy when one child is living far away, or when it's very easy when you have a person with significant assets, because with assets you are in wealth fortune, so you know that at a certain level of assets, the judge he has so many files that it's a problem for him. So people with significant assets, they do all the time a mandat de protection future. After, as I was saying, for a family without any problem, everybody's living in the same place, the assets is not important. And they say, oh, maybe we will do a mandat de protection future. I explain, I must explain, because I am a public officer, that there is the habilitation familiale who could be fine in case of. But no, really, we have absolutely no difficulty to convince, because in some family with significant assets, they always have a person put under tutel, and in some cases, there is no damages, but some problem due to the delay or to the difficulty to make understand the project of estate planning, and so it's very easy.
Yeah, and a follow-up question. When you're talking about needing this extra layer of authority, when you're gifting as a guardian in both Scotland and in France, I can see that would cause a problem if that's the authorization's taking many years or many months to a year to come through. Backdating in terms of the likes of inheritance tax and calculating as a potentially exempt transfer, this gift that's being made.
We have to take it in advance.
Right.
Yeah. Yes. Yeah, it's a long, because when we make an application to have an order authorizing the tutor or curator to act on behalf for the tutor, to act on behalf of the person to make a donation, we have to, it's not only a form, we have to produce like an appraisal inventory, detailed inventory of all the assets of the person. Most of the time there is no liabilities, to see, to show to the judge that the assets are important, and that there is some witnesses who say, when he has his mind, he always say, I want to give a little bit of cash to each of all my grandchildren, which is always the case, and so we have witnesses, and we say he has 9 grandchildren, and he wants to give the tax allowance in France of which is 31,000 euros per grandchild, and let's say it will do maybe 300,000 euros, but he has significant assets aside, he has life insurance, he has his main residence, so the donation won't be any damage for him, but it could take 7-8 months. So we have to take in advance, in case of sometimes there is a tax allowance which disappears when the person is 80 years old in France. So you are completely right. You have to do that, let's say 2 years before.
I would be the same here. You would have to get that authority in advance, but it's much quicker to get it from the OPG. It generally doesn't take as long. And if you've got a power of attorney, you don't need to ask. So
Thank you.
Thank you.
Thank you very much, everyone.
Thank you.
Listening.
Thank you.